Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39377, State versus Powell. Can I have entries of appearance, please?
Good morning, Your Honor. Nicholas Hart for John.
Good morning, Tessa Ryan for the state.
Thank you. And Mr. Hart, it appears that you have elected to use all of your time in your opening argument and reserving none for rebuttal. Go ahead and tell me how you'd like to split your time.
If I can reserve 5 minutes.
So 25 and 5. All right. Thought that was a little off. All right, Mr. Hart, take it away.
Good morning, and may it please the court. John Powell asks that the court vacate his convictions for burglary and first-degree murder for 3 reasons. First, that there was insufficient evidence to support the conviction for burglary because Mr. Powell was authorized to enter Ms. Brown's dwelling. Second, that there was fundamental error when the state misargued the essential elements for burglary during summation before the court. And third, that there was insufficient evidence to support his conviction for willful and deliberate first-degree murder. To start with the sufficiency for the burglary charge, what had occurred in this case is that the district court has combined the two of the essential elements into a single element for burglary, combining both the unauthorized entry element and the intent to commit a crime within. But the New Mexico Court of Appeals got it right in Baca when it stated that those are wholly separate elements and that there must be proof beyond a reasonable doubt for both. So both that there was an unauthorized entry into a dwelling wholly separate from any intent to commit a crime or a theft therein. And the state's reliance on Ortiz and James doesn't change that ruling from Baca. First, James, which is a New Mexico Supreme Court case, was a different issue. Right? In James, the question was whether federal bank robbery convictions could be used as an underlying offense for the habitual offender enhancement. So we're not dealing in that case with what are the essential elements for burglary.
Here, I think why, all that aside with the district court, why do you still win with the facts that we have? Because seems like him and his girlfriend, the defendant and his girlfriend had already moved out, taken their stuff. Why was it an authorized entry?
So the only way that the court could properly look at this is by applying the statutory law that we have for these relationships, for oral lease agreements, and for other types of lease agreements, because in Mr. Powell's opinion, it would be untenable to have a separate common law just for the criminal burglary statute, right? So when we look at that and apply that law to the undisputed facts that were below.
So you're saying there has to be a lease?
I'm not
Is that
saying
what you're saying?
there doesn't have to be a lease, but in this case, there
wasn't.
was one. Well, there is an oral lease, Your Honor, and that
Okay,
is recognized under the statutory law.
and surrender is also recognized under law currently, correct?
That is, the state seems to not contend whatsoever that there was surrender, but I think we also then have to separate out Ms. Chavez and Mr. Powell, right? So the conversation between Ms. Brown and Ms. Chavez did not include Mr. Powell, and also did not include any explicit statement in the record evidence that there was actually a surrender.
Except they moved all their stuff out. That's my understanding of the record, except for maybe some tools. So isn't that evidence of surrender? There's a dispute. I don't care what you do. Well, to heck with you. And they get their stuff and they leave.
So,
Isn't that surrender of an oral lease?
so that is the truth for Ms. Chavez, but Mr. Powell still left some of his belongings.
But they
Yeah.
left together. They basically acted as a unit and said, we're leaving, and left together. He didn't say, but wait, I'm not moving out, I'm staying. How do we get there? How do we get where you want to go from with those facts?
But there was also no statement that I am leaving with her and that I am surrendering. So we're trying to apply a conversation between Ms. Brown and Ms. Chavez.
But surrender, go ahead, sorry.
Mr. Hart, it sounds like this back and forth sounds like there's an issue of fact for the jury to decide as to whether or not there was an unauthorized entry.
So that could,
There's different inferences can be drawn from different facts.
so that could be, Your Honor, but that then gets down to whether these inferences, are how the inferences are being drawn and based on the evidence that was presented specifically at the trial. And I think in this case, Your Honor, what we do have is that Mr. Powell had additional property there, that Mr. Powell, there is no statements regarding Mr.
People
Powell
leave
saying
things that, hotel rooms or that they've checked out of, or apartments they used to live at. It seems to me what you're asking this court to say is based on the evidence as a matter of law, take it out of the hands of the jury as a matter of law. There was not an unauthorized entry. That's what we would have to do to rule in your client's favor. Is that right?
that's correct.
Okay.
But the difference with your hypothetical, Your Honor, is that what we do have under the statute is there is a certain limited time period where an individual does have a right to return in order to either remove those other items or
But
before
the
there's
right to return doesn't invalidate the yielding of possession. I mean, I've moved out of many apartments in my life, as I'm sure many of us have, and you realize I left my coffee maker. And you say, can I come back, get my coffee maker? It doesn't mean I haven't yielded possession of the premises. What's our standard of review on this question?
So this is a sufficiency of the evidence standard of review. So we are looking whether there is
On
substantial.
the oral lease?
Yes, so whether there is substantial evidence to support whether or not each of the essential elements were going to be under reasonable doubt. So, and I would just say, Your Honor, that as for, kind of the typical scenario of leaving an apartment that one rented and leaving something behind, that's not what the evidence was in this case. The evidence was not in this case that Mr. Powell merely forgot something at the home and decided to go back and get it. The evidence in this case, based on Mr. Powell's testimony with nothing that contradicts it, is that there was no,
Wasn't that the argument that was made at trial, that he was going back to get his tools, not that he was going back planning to stay there or to live there or to sleep there? It was that he was going back to get his tools.
so that was the argument for why he was there at that,
Right.
at the time of the offense, but that doesn't change whether or not he was authorized to be there at the time of the offense.
Well, it can affect how the jury looks at the purpose for him being there, whether he was just coming to pick things up because he'd moved out, or whether he believed he was authorized to be there and could be there whenever he wanted, however he wanted.
Well, and I don't think that the question, Your Honor, is whether he believed that he was authorized to be there. Really, the question is based on the Uniform Owner-Resident Relations Act, which is the only statutory, which is the
What
statutory law.
in Aurora says you leave, you've left something behind, you have unfettered right to go back in and get the thing you left behind? What in Aurora says that?
So when there is no explicit cancellation of the lease by the owner in Aurora, there is this 7-day period where before the abandonment, before the leaving.
Well, now you're going to abandonment. That's a totally other issue in this case. And we're talking about yielding possession. And the yielding possession under an oral lease is, to heck with you, I'm leaving. And so what in Aurora says then, without any consent or permission given, you can go back in and get the coffee pot you left behind? What in Aurora says that? It's not tethered to abandonment.
So there's nothing in Aurora that says that, your argument, but that would only apply to Ms. Chavez. Ms. Chavez is the one who said that she was leaving, and Ms. Brown said, do what you want.
He left with her. He didn't come back for a week or 6 days or
I believe that it was
the
only 3
23rd to the
days.
29th, something like
I
that.
think you can get the sense we're not buying this one.
And-
So you might
Yeah.
want to go to some other
On
arguments.
on the chief's point, let's help you move along here a little bit. You also make this implied license argument. I wonder if you're still standing on that. I'm interested in that. I'll tell you what I'm more interested is concept of a dwelling within a dwelling. And assuming what you are saying is true on both, why does that fail once you get inside of the room in which the decedents were found? Can't we have a separate dwelling within that larger dwelling?
So first, yes, there can be a separate dwelling within a dwelling, especially Rogers and Towers, the way that has been applied across shows. For example, entrance into a hotel does not mean entrance into the private office spaces. So that could certainly be. And I do agree with your honors that this is certainly the more critical and pressing issue. When it comes to Rogers and Towers, then when we're applying that to this case, what the evidence showed was that both the room and the house were used as part of this drug operation. And in fact, it was leaving the house, that the record showed was the personal time and the personal place to not be disturbed. Even I believe record evidence saying that if I didn't leave the house and if you didn't leave me alone outside the house, I would be working 24/7.
So the concept there, as I understand it from your argument, is open for business. It is in notion of our what we would consider a lawful business. You can come and go. My question is, what would, if we were to decide the case your way, what would that do to warrant requirements? What, couldn't an officer walk in and say, this is a drug house, just like a 7-Eleven, right? I can just walk in, I can look around and just see what's going on. I don't need to see a warrant. Is that, you can tell me if that's unreasonable, but I had concerns about your position in this case because I thought, well, could an officer just say, okay, if it's a 7-Eleven, it's a 7-Eleven or an Allsup's, and I can walk in, I can't search things, but I can look around. Is that fair or not?
I mean, I do believe that that is a correct application of the warrant law, which is if something is generally open to the public, they could enter to the point that it would no longer be open to the public.
So an officer said, this is a drug house. It's used commercially as a drug house. They do not need a warrant to walk into that house.
Assuming that the facts actually establishing that are present. and
Well, but,
assuming-
so that's a really good rule for your client. It's a terrible rule for every other defendant out there selling drugs, isn't it? Because then it's just, it's a walking in this case, into the house. You've got the list of drug prices on the wall. I mean, it's not Twinkies, it's list of drug prices on the wall. So an officer can just walk in. I think it's a very interesting point, Justice Thompson. And they're gonna walk in and be like, yep, drug house, and do everything they need to do without a warrant. And every other defendant's gonna be really troubled from a constitutional perspective with that.
Well, I think that,
announcement.
I think that what's missing there is at what point would the access be prevented without a warrant, right? And of the.
But if you want it to be like 7-Eleven, it's like 7-Eleven. There's no shades of gray, like on Tuesdays at 4:02, it's open for business. You're asserting here that it was open for business all of the time, and the only time it was closed for business is when the decedent wasn't there.
No, I think there's two distinguishing factors. First is when it comes to 7-Eleven, there are, of course, administrative search law, and there are all types of regulations and statutes that give inspectors.
That
and
doesn't matter.
state-
You're saying, because you're still saying that this house was open for business 24/7. And for purposes of criminal law, it's either open to the public and you do not need to, and it's an authorized entry or it's not. All these other regulations, I mean, it's either open for business or it's not.
Well, I don't think that it's that simple for every single room in a building or a dwelling. The only two things that are at issue here are entering into the home and the room itself where the drug transaction.
So those are the two rooms, that's big, that are open for business to all of us. All of us can go there right now and walk in and do our business.
Well, of course, I deal with the record below, right? And on the record below,
And you have
those
quite a
are
record.
the two rooms, right, that are at issue in this. There's obviously, we could see there are other bedrooms in this residence. It's not clear to me, based on the record, how, that would work and if it would extend beyond that. And there's all types of ways and exceptions to the rule.
But you
where there
think
are entries to
anybody could go
dwellings.
into those two rooms, the entry of the house and the bedroom? And it would be an authorized entry?
I think in this case where it is invited, yes.
Okay.
And
And anybody, not just certain people that are regular customers, anyone, any member of the public could have gone into those two rooms.
I think the law of warrants well recognizes that when you take an action like that, you assume the risk that one of the members of the public who walks in may not be a regular member of the public. The same way with any other building or place where there is the public entry that is allowed, right? So again, behind in the private locations of any dwelling or even in any commercial establishment, that is a different question than walking in the front door of the 7-Eleven and just being in the customer area. Right, so those are two separate questions, and the facts below here make these two rooms no different than that. And like I said, this is, where I'm here with just the record below, not as the person who knows all of the discovery from the trial. So it's those two rooms to me that supports.
So where do we draw that line? If we issued an opinion in your favor, where do we draw that line? At what point does a dwelling become a business that's open to the public? And again, we're just focusing on the 2 rooms, but that's where all the stuff happened. And that's where all the drugs were. So I just wonder, where do we draw that line? Is it, if they have a price list? Is if they have a different set of customers? Is if they leave their door unlocked? What standard do we apply? Because I'm really concerned about saying people's dwellings are similar to 7-Eleven.
So I think we just apply Rogers and Towers, Your Honor, which is unconditional public access.
Mr. Hart, was a requested instruction submitted on that point?
I do not believe it was. So the only requested instructions were step down instructions from the defendant. But I do think, Justice Zamora, that you apply Rogers and Towers, and here you have unconditional.
What do I make of the fact that the front door was locked?
So what the testimony shows, what the testimony established was that Mr. Powell and most individuals, at least according to him, would enter through that back door, and that back door, I don't think anyone said specifically was unlocked, right? But it's certainly implied in the access that was given. So I believe he actually testified that he entered the house the same way he has always entered.
But isn't that a
Because he
jury
lived
question?
there, he wasn't just a customer. I mean, there's some facts here that I think belie that it was open access to anyone as a business when the front door is locked. He knew about the back door being unlocked because he had been a prior resident.
So I feel, I would say that in the many cases I end up before you all, dealing often with what's called buildings or dwellings where unlawful activity happens. It is actually quite common that the known entrance is the back entrance and not the front door. There was no argument about that in this case. It was not something that the instruction was requested on. But it is actually quite common in these, let's call it an industry.
But don't I view all of this in the light most favorable to the verdict?
We do view it in the light most favorable.
And I indulge all reasonable inferences in favor of that verdict.
Yes, that is the standard. That is the standard, Chief Justice Bacon. I would just submit, as we do in our brief, that the most favorable inferences here to the verdict are that, and it's difficult because it's not conceded, it's just kind of an alternative argument that is in there, but it's pretty close to a concession. Even if you believe that he could enter, even if you believe that he could return as a resident, it was still unauthorized. Now, but what I think is important, Your Honor, is that, and this is page 11 of the answer brief too, and this is where I think the real issue, both in the district court's decision and in the way the argument was made to the jury, which is the way the law ends up being presented, is that if you enter for a legal purpose, that it is an unauthorized entrance. And that just is not correct, Your Honors, as far as our burglary statute, because the authorization and the intent to commit a crime are two wholly separate essential elements, both of which need to have proof beyond a reasonable doubt. What I would ask at minimum here, Your Honors, is to take the opportunity for the first time to make clear that the delineation is there.
So I can see a path, and you're not going to like this observation. I can see a path because I agree that the district court looks like they collapsed the 2 prongs. And I think that Ortiz a little bit leads to this because, or excuse me, James creates this problem because James misquotes Ortiz. And I think there's something to be cleaned up there. But ultimately, we still have the right for any reason doctrine. And I'm not sure your client gets past that, even if I agree with that mishmash in the law.
So I understand that, Your Honor, and what I would say is, as an advocate of the law before this court, at minimum, the court should take the opportunity to clearly draw that line the way the Court of Appeals did in Baca. To make clear that we're not back here again on future cases.
Right, because otherwise anybody walking into 7-Eleven with the intent to commit a robbery, it becomes a burglary in every single instance, and that does trouble me.
That is correct.
Yes.
At minimum, I would ask the court to at least address that issue because it needs to be addressed.
You still maintain though that if they entered under false pretenses, I'm the cable provider, and I'm not, and I entered under, that would be unauthorized.
That's
But that
correct.
doesn't seem to be what the district court did. They just said they had false pretense in the sense of I had a different intent before I came in, which is, I would think not, it's false pretenses, but not under what our case law requires.
I agree, Justice Thompson. I think it's an unlawful use of false pretenses by the district court, in the middle of a trial. The false pretenses under Ortiz is still good law and should remain good law. And that says if you approach and you use some type of coercion or fraud or some type of lie in order to get access, that is not an authorized entry. But I don't believe that the silent intent of an individual should bear on the false pretenses argument, especially because it is a wholly separate essential element under our statute and under our UJIs. I'll also say, Your Honor, I think one of the key issues here with the sufficiency argument for the burglary was that it's not merely the district court conflating and collapsing these two elements during the directed verdict stage, but it's also the state making the argument to the jury during summation without any opportunity for the defense to be able to correct it. Of course, we concede in here we are on a fundamental error standard, but there is certainly a large amount of factual dispute here over whether there would have been an authorized entry or some type of license to enter, and the state being able to argue the law incorrectly to say that even if you believe he had the right to be there, then it is still a burglary because he intended to kill should be a fundamental error here, because there is the question of whether it was a burglary underlying it in the first place.
So usually lawyers lead judges to error. Here, a judge led the lawyer to error.
It may be. I don't think that it's unclear to me, but it certainly may be, right? I
thought it was, you got through the directed verdict. The judge says this is okay, so the lawyer in closing argues it. I'm not disagreeing with you. I just think it's interesting. What is the requirement of the state? They were saying something probably incorrect as a matter of law, but at the directed verdict stage, the trial court said it was acceptable.
Right, but I will say we're not alleging prosecutorial misconduct. We're not alleging a knowing misstatement of the law here. We're saying that the way that it occurred before the court is fundamental error, especially because the defendant has no opportunity to address that at that point. Of course, an objection could have helped, and that's why we're on fundamental error. To just wrap up quickly, the remaining arguments, the court, it's just a pure factual argument on sufficiency for the first degree murder. If the court has any questions, I'm happy to answer those, but those arguments are laid out in the brief. To the extent, though, that the court agrees that there was no burglary, whether under either theory, then we do request also that the felony murder conviction be vacated, not because of any inconsistency, but because there would have been no underlying felony at all. So with that, Your Honors, I ask that the court vacate the burglary and first degree murder convictions, and I will reserve my time for rebuttal. Thank you.
Ms. Ryan.
May it please the court. This case is not a good candidate for reversal. To vacate these convictions in any of the ways the defense proposes would entail stretching the law and the facts past all reasonable limits. There is indeed sufficient evidence of an unauthorized entry and of defendant's deliberate intent to kill. Not only was the evidence of an unauthorized entry sufficient, but to take this issue a step further, the record is devoid of evidence that the entry was authorized under either the theory that defendant was still a resident on the night of the murders, or the theory that any member of the public, including him, had permission to walk into the home anytime they please because it was a so-called drug house.
Ms. Ryan, I'd really like you to spend some time leading us through what do we do with the district court's conflation of the law here that I think is led primarily by reliance on James. What do we do with that in this case?
Certainly, Your Honor. I would actually argue that it's not necessary to reach that question or that analysis in this case, and that's because the fact is the only one saying that defendant was a resident or a public member of the public at large who's always welcome in the home, frankly, are the defense lawyers in this case. The record just does not support these allegations of fact. They're not there. So the factual predicate for that question doesn't exist. No witness, not even defendant himself, testified to either of these things. And to the contrary, his testimony actually established that he, as you know, had moved back in, or had moved out, had not moved back in, and that drugs were not sold to just anyone, and certainly not at any time of day or night, and there were limits to who could purchase them. As you know, arguments of counsel are not evidence.
Okay, so Chief Justice, we understand your sufficiency. Chief Justice, I think, is asking, you had a ruling, a directed verdict that I think, at least for a number of us, was incorrect. Because the judge said unauthorized entry means I can change my intent before I go in, and that makes it unauthorized. That seems to be clear error. It just seems to be an error. Then at closing, the state takes that, at least in part, and says, yes, this was the unauthorized.
Right, okay.
So the question is, what do we do with that legal conclusion that the district court raised, and how does that affect the ultimate outcome given the verdict?
Your Honor. Essentially what the court did was it assumed that what was being argued was true. Fine, let's just accept this idea that the defendant was a resident of the home and that he was a drug buyer. Welcome, like anyone, the police officer into the 7-Eleven, everyone can walk in at any time. They have April's permission by virtue of these statuses to enter the house at will and unannounced. The district court judge then said, probably as an efficient way to make his ruling, let's just assume that, granted, if defendant had entered the home in one of those capacities, now that would have exceeded his permission given by April, the homeowner, meaning she never said that you can come in under the guise of a drug buyer and commit these crimes in my home. That was not part of the permission given. No drug buyer was implicitly entitled to just walk through and do.
But that's always,
other
there's a armed robbery at 7-Eleven. You're going in with the intent to commit the robbery. That's not the tacit permission given. So you're elevating every single case involving a 7-Eleven to burglary. Every single case with that argument.
Your Honor, I would actually argue that there is an instance where those are not the one and the same. I don't think these elements blend into each other or that the one satisfies the other in every case. And I would point out to you the example of, take for instance, a homeowner who has a devious mind, invites a hitman into the home to kill her or his guest. You would have an authorized entry. That homeowner says, please come on in. And you would have an intent to commit a felony inside the residence. That would not be burglary.
That still doesn't
But your
answer.
hypothetical, nothing was taken.
Burglary covers both theft and intent to
I understand that, but
felony.
nothing was taken, as in this case.
That's just conspiracy to commit murder.
So,
The burglary statute contemplates aggravated burglary that you, the person, the accused, have the intent to commit a felony inside. It need not be a theft.
But going back to the Chief Justice's question, your hypothetical still leaves me with the concern that individuals who go in and commit murder inside 7-Eleven will also have an aggravated burglary.
I would point out too that 7-Eleven is in fact a public establishment. What we have here is a private home. This particular homeowner never gave permission to have defendant enter as a drug buyer. We don't have the evidence of this, I should say. There's no record evidence that she.
Yeah, but didn't the district court presume that, okay, defendant, you made these two arguments, that's fine, I'll agree he's a resident or, you know, this house is open to the public. Didn't the district court's conclusion take that premise into consideration when it decided that it was his intent that, it was his intent, sorry, I'm having trouble articulating this question. So if you don't understand it, that's okay. It was his intent that caused it to be an unauthorized entry.
I don't think that's what the district court judge was thinking.
Okay,
this
I
was
think
the-
that's
That's what he
what
said.
he said. He said, well, because you were going in to commit murder, your entry wasn't authorized. I mean, that just that collapses two very distinct elements set forth by the legislature into one. So assume with me that I'm right. You know, just assume. What do we do with it then under our standards? If we think the district court judge collapsed these two elements into one and incorrectly denied the directed verdict, what do we do with that on this record in this procedural structure?
I would still argue, Your Honor, that it is not necessary to reach the question because we just don't have the facts to support this argument in the first place, that the defendant was a resident, or that he had April's permission to enter the home because he was a drug buyer.
That doesn't answer the question. Not a resident, not open for business. The district court judge said because you were going in with the intent to murder people, it doesn't matter whether it was authorized or not. That it's fraud or deceit to enter because of your felonious intent.
I still don't think, if you look at the record and listen to what the district court judge said, those were not his words. He said, we have two elements. One, the issue was the unauthorized entry. Focusing on that, he said, let's just assume that he had entry under either of these guises, the capacity as a resident or a drug buyer. Even then, the permission April gave him did not come within those scopes.
Well, it's nobody's ever gonna give permission to come in and murder me. I mean, it's collapsing on itself. The 7-Eleven clerk doesn't say, come on in and murder me.
Of course not.
Ms. Ryan?
And I don't think that's necessarily problematic for the reason I just explained, that just because two elements of the statute happen to, you know, in some conceptual way be satisfied in a particular circumstance because of the nature of the past,
Ms.
doesn't
Ryan.
mean that they're invalid.
I think what the chief is asking is, correct me if I'm wrong, assuming that the basis for the judge's ruling at directed verdict was legal error, why do we not reverse?
What do we do with it?
Your Honor,
Tell us why we do not reverse, assuming, I know you don't want to assume, but assuming that was a legally erroneous ruling.
because the question in this appeal is whether there was sufficient evidence of an unauthorized entry. And I think without any doubt, there is sufficient evidence of an unauthorized entry. His ruling simply didn't change the nature of this case. I'm prepared to explain more about why there is sufficient evidence of that unauthorized entry. So again, what we're talking about here is whether the defendant had permission from April, whose home it was, to enter on the night of the murders. The evidence was uncontroverted that the defendant had moved out 5 to 6 days before the murders, as you all know, and had never moved back in. Even he testified that after the dispute between him and his girlfriend,
Can I ask you to assume that the court feels there is sufficient evidence for the reasons already stated of unauthorized entry? Getting back to the Chief Justice's question, because of that erroneous ruling, assuming it was erroneous, the district attorney was allowed to argue in rebuttal an incorrect statement of the law to the jury. And bearing in mind, this is rebuttal, the last word to the jury. Does that still leave us in the same place?
I think that that statement of the prosecutor, which was a pretty brief, in the grand scheme of things, statement, does not rise to the level of fundamental error.
Why not?
Because fundamental error is, as you know, a very high standard to meet. For one thing, I'll also add this before I get into that. The context of her statement is important. So the defense has taken it and shined the spotlight on it. What she said before that statement and after are relevant too. Before the statement, the prosecutor said, the defendant did not have authorization to enter the residence. First and foremost, he and his girlfriend had left. They had packed their things and left the residence. It doesn't matter what the defense urges, which is that there were no trespass signs or barriers to coming in. Okay, so she's refuting the argument that there needed to be some barrier to his entry. Then she makes this statement, which is not that you may find him guilty if you believe that he had authorization to live there or to purchase drugs there. She said, even if you want to believe that he had authorization to be there because he lived there in the previous days, even if you believe that he didn't have authorization, he maybe had authorization to live there, okay. He maybe had authorization to buy drugs there, all right. He didn't have authorization to go in there and kill everybody inside that residence. So no, his entry was unauthorized. She didn't actually say that you may find him guilty if you believe those two things.
But she basically summarized what the district court judge had said. And I just wanted to ask you this because I'm looking at what the district court judge said during the motion for directed verdict. And he said, it would have been based on a false pretense of entering for the lawful purpose of peacefully residing inside of the residence to which he was a tenant. It is a false pretense in the sense that that was not his purpose for entering, assuming he is one of those individuals. The intent of those individuals was to enter into that residence undetected, armed with firearms to commit the acts which are contained on the video. And these types of actions are never authorized. So it does seem to me, I guess I'm wondering if we think that that's not true, if we think that you need more than just an evil intent to find unauthorized entry, shouldn't we clarify that for future cases?
Again, I think that this question isn't one that needs to be reached to resolve this appeal, Your Honor, but I would also posit that this is not actually a radical idea, that the unauthorized entry can be found where the defendant exceeded the permission given to enter, in this case, the residence. I think it's
But is
safe
that
to
up to us to be doing that? Or should the legislature write that in the statute?
Well, we have case law, Ortiz, which states that where the consent to enter is obtained by fraud, deceit, or pretense, the entry is trespassory because it's outside the consent given. So again, it's outside the consent given. She had perhaps, and I don't actually believe this, but given him some type of permission to enter the home in capacity as a resident, in which he would come and do some work for her and sleep on the living room floor, otherwise go about doing his thing. no, he did not have permission by her to go in and commit crimes, and certainly not on that night.
This is where the conflation, this is where I struggle with conflation, because again, we're writing these for other cases, right? So someone that is downtown enters a store to look at the jewelry and then decides to steal something. The store owner, to the Chief Justice's sort of, in this case, the murder question, the store owner is never saying, please come in and steal jewelry. That's ridiculous. So in every circumstances, how are we not conflating this under this theory? The problem here is the district court based its unauthorized on the deception, and that deception was not something like I work for the cable company, it's my internal intent. I'm deciding you had a different reason to come in. How would this not in that jewelry case, why wouldn't we conflate these two crimes all the time? As soon as they come in and take that jewelry, you say, well, that wasn't authorized.
Justice Fountain, I again don't think this is problematic because there is an instance where the entry would be authorized and there would be this intent to commit a felony. And that is the example I gave, which is that of the hitman. The legislature simply wrote these two elements into the statute. It did not, these are in fact distinct ideas.
So every theft is a burglary. Every theft is a burglary in a commercial enterprise. Let's go back to 7-Eleven. Pick one. How is, ask it directly, how under your rule you're announcing every theft is not a burglary?
Your Honor,
And I
Except your
know,
hypothetical.
except your hypothetical, which reverses it. I love that hypothetical, but and I know we appreciate our work of our district attorneys, but they will charge this. How is every theft not that burglary?
I believe there's a case, Your Honor, in which a defendant walks into a store not with the intent to do anything wrong. This is an older case. And then devises that intent after he walks.
That's a separate case. We don't have, this is, going in and saying, I'm gonna buy a Twinkie and then saying, oh, I forgot my money and now I'm gonna steal, now I'm gonna, I've got a gun and I'm gonna commit burglary. That's not this case.
That's right. You're right, Your Honor, but that's an example of how it would not be burglary.
No, but we're
to-
talking about elevating somebody who says, I'm gonna go into 7-Eleven and steal money, and I've got a gun. Their entry is authorized because it's open to the public. They have, felonious intent on the back end. This would collapse every single one of those cases into burglaries. Every single one.
I suppose it would.
That's a huge shift. That's a seismic shift in criminal law jurisprudence.
I think it isn't necessarily. I think that our legislature chose these two elements. They cover different concepts, and it just happens that no one would ever give permission to the member of the public who's coming into 7-Eleven to rob them, to steal their goods. That is outside of the scope of the permission given to the
So,
public.
Our case law is wrong.
Unauthorized.
All of our case law is wrong, and the UJI is wrong,
No.
because it requires separate proof for each of these elements.
It is separate, Your Honor. They can be seen as distinct ideas. They happen to kind of coincide in these examples.
But again, assume with me, all 5 of us disagree with you. We think that there was legal error. What do we do with it?
I think you can, as I've said before, Your Honor, disregard that. I do. I believe there is sufficient
On what-
evidence in this case, because we are, of course, concerned with the facts of this case. In this case only.
So the
There-
facts are gonna overtake the idea that we think that a legal error has been committed.
I think because that legal error did not influence the outcome of this case. It went to the jury.
How do we know
Jury-
that? How do we know that the rebuttal closing argument did not persuade some jurors to convict this defendant of burglary? because he came in with an intent to commit murder.
Because, Your Honor, there was.
How do we know that that's not the case?
Because there were no facts saying that he was a resident. There were no facts adding up to his being a person invited to enter the home because he lived there. He had gone. He had
There
left.
are facts. I think we've established in Mr. Hart's argument that there's issues of fact on that question. Or do you say that all the facts show unequivocally, without dispute, that he had no permission to enter?
That is what I say,
Okay,
yes, Your Honor.
thank you.
I can elaborate on that in the time I have left, particularly with regard to the drug house theory. I'll wrap up actually by talking a little about the insufficiency of the authorized entry. So I think the plainest proof of an unauthorized entry in this case comes from the evidence of what happened on the night of the murders. Defendant and his brother had parked at the bottom of the hill, not the top, and walked in through the back door. These were places where they wouldn't have been seen on camera. He knew this because he was the person who installed that camera and installed this surveillance system. He was trying, along with his brother, to avoid detection. If he had had any kind of permission, explicit, implicit, by April, that his presence in that home were welcome, he would not have done these things. I'll move on to the sufficiency of the evidence that, well, I should say there is no evidence. My point that there's no evidence that this was a drug house open to the public, all members, law enforcement, you, me, the world, all times, every day. And this is going to the defense's statements in its briefing that April implicitly authorized members of the public, including the defendant, to enter her home, which she operated as a drug house. The defense also says that members of the public were essentially granted unfettered access to her home day and night, both to purchase and to use drugs. The evidence in this case does not support these statements. No one at trial said that all members were invited in or that access was unfettered. No one said that those who did buy or use drugs had permission to just walk in as though it were some kind of 7-Eleven.
Well, and to Justice Thompson's discussion with Mr. Hart, what would this do to warrant requirements? Do you agree that if we were to write an opinion in that direction, that the warrant requirements for drug houses would just go out the window?
I do agree, and I think
Might be great for your client, not so great for defendants.
I think this, you have to remember, was not just, we say 7-Eleven, but it was a home. More than anything, it was a home. And April did not invite just anyone in. The testimony established very clearly that it was only select people, really the regular customers, who had permission to come in. And even then, it was not 24/7. Priceless might have mentioned something about how she basically works 24/7, but it also said to respect her time when she's not working, meaning store is closed. It refers to her personal time and her time off and time when she did not want people to bother her. So this idea, I think, is just not grounded in the record in this case. I think probably this drug house and every other drug house out there, those people operating them or who own them and who have a say in who comes in them are not saying that the world at large may come in any time.
Is there anything in the record besides the defendant's own testimony about the idea that the front door was locked and whether that had any significance? I think Mr. Hart said, well, it's the defendant who testified that the operation of the business was through the back door. Is there anything else in the record to support that idea?
I don't recall that there was testimony about the doors being locked or unlocked. They were sometimes locked, sometimes not locked. The defendant, in fact, even often got upset at people who would just walk in the door when they did that because April's permission didn't extend to anyone coming through. These were not sliding glass doors that, detect your presence and open wide up. They were doors and sometimes, again, locked and unlocked.
We need to concern ourselves with, again, we'll just take this as an assumption, that they were invitees or they hadn't surrendered. But they had a right to the common space, and then there's a private space within that house in a shared living environment. And it's that Mestis case, the motel lobby. Are there any other cases that help us define certain rights to enter a private space within a larger building, within common space?
There's another case, his name doesn't come to me at this moment, Your Honor, where someone, it was Presbyterian Hospital, and someone entered a private office in the back of that hospital, so it went beyond the scope of the public's, the space open to the public. I'm sorry, I don't recall the name of that. But again, I would just urge you to look closely at this record and realize that these arguments are built on facts that are not real. They were not brought out in evidence at trial. And I think that many of these arguments can be disposed of rather summarily by focusing on that fact. I'll go ahead and just wrap up. The evidence of an unauthorized entry and a deliberate intent to kill in this case is beyond sufficient. The jury could hardly have not found those things. And while the district court's reasoning in denying the directed verdict motion, the state's position is neither here nor there, it was in any case a sound position. The same goes for the prosecutor's purportedly, controversial statement. There is no error to correct in this case, and you should have no trouble affirming the defendant's convictions.
Thank you.
Thank you, Your Honor.
I would just like to address, Your Honors, I think the main question, excuse me, that was posed to the state, which is what do we do with this? And I do believe that in this case, there's the answer of what we do is reverse and remand because of fundamental error. And of course, it applies to that burglary conviction. The burglary conviction brings with it the felony murder convictions. But to talk about the state's hypothetical regarding the hitman that is brought in this unauthorized entry, I think that that creates even more problems than the court has asked in the briefs, because it would also state that a homeowner, who commits some type of felony, whether it be against a family member, or it could even be some type of theft, within their own home, could potentially, would add a burglary conviction for everything that they do, because the state's argument is that it's not about the theft, it's about any felony they're in. So if anyone commits a felony within something that could be considered a dwelling, whether they had the right to be there or not, would be a burglary. And to me, that's even more troubling than the person who walks into the 7-Eleven, because it also brings it into the home and brings it into other non-public spaces where someone may have the ability to enter. And the state's main argument as for this, the summation argument, is that it didn't change the nature of the case, because they didn't say you should find the defendant guilty because of this issue. But the argument was that his entry was unauthorized because of the intent to kill. And that is an error, not just during the initial stage, not just during the directed verdict, but also in summation during the rebuttal summation to the jury in a way that could not be cleaned up. And we submit that that's fundamental error, and that what the court should do is do exactly what the Kentucky Supreme Court did in Harper, which is address that these are two separate elements, and to collapse them into a single element is an error that requires.
Assuming that's true as a legal matter, but isn't it also true that the same evidence can prove both elements?
Yes, so it is true that the same evidence could sometimes prove more than one element. But what is happening here is not the evidence itself, right? I mean, the evidence itself is the entry into it. What instead is the court and the state argued that the intent during the entry is what made it unauthorized. And that can't move over, the mens rea can't move over to the actus rea, Your Honor. So, in this instance, I would just ask that there is fundamental error when it as related to the argument, and that it is sufficient for this court to reverse. And just to make a final pitch again, that regardless of how the court rules with me, we do ask that this issue regarding the separate elements be clarified going forward. Thank you.
All right, counsel, thank you for your arguments. The case is submitted as of today. Thank you.